morning to hear oral arguments in the case of Karvo Paving versus Joseph Testa, State of Ohio. Each party will have 15 minutes which present the case. I realize that there's cross appeals here as well. And you discussed doing that all at the same time.
That's acceptable.
Okay. You may reserve 5 minutes for rebuttal of the appellant. If the appellant wishes to retain some of that time, let me know when you come up to the podium. I'm keeping track of the clock and keep you apprised of the passage of time. We are being visually and audibly recorded and be posted online, so please try to remain behind that podium as much as possible. We have read the briefs and we're ready to proceed when you are.
Thank you. May it please the court, Dan Fawcett, I'm Assistant Attorney General in the Office of Ohio Attorney General Mike DeWine, here on behalf of Joseph W. Testa, Tax Commissioner of Ohio. I'll reserve 2 minutes for rebuttal if I can. This court should reverse the decision of the Board of Tax Appeals for 2 reasons. The first is that there is no resale of the traffic maintenance property in this case. A survey of the Supreme Court's cases set out a dividing line between when property is possessed by the consumer or when property is merely directed in its use and operation by the consumer. So essentially you have a service contract versus a lease. In this case, it's a service contract where the consumer, in by and large the state of Ohio, directed how the property was to be used, but at no time possessed it, and accordingly no resale to the state of Ohio occurred. The second error committed by the Board of Tax Appeals was with regard to the lease of labor between Karvo and K&H. When a person leases labor from another organization, that's a taxable sale in Ohio, with certain exclusions that apply. One of those exclusions is affiliated entity exclusion, which the board erroneously found applied in this case. And what the board failed to do is look at, consider, and apply the second sentence of the very statute that sets forth the affiliated group exclusion. That sentence says very clearly, lays out a manifestly objective test that in order to be an affiliated entity, in the case of a corporation like Karvo's an S Corp, that corporation must own the majority of the voting shares in order to own and control the other company. And in this case, that clearly doesn't exist. Karvo, as an entity, doesn't own any shares of K&H. And Mr. George Carbonitis, who's during this time period was the 100% owner of Karvo, was a minority owner of K&H. So by the plain and objective language of that statute, they cannot be affiliated groups. So let me start with the resale issue. As I mentioned previously, if you survey the Supreme Court case law that we've set forth in our brief on this includes Flightways, Laurel Transportation, Stein, Al Johnson Construction Company, and R1's Construction. The Supreme Court has basically laid out a pretty clear and easy to apply standard, and that is when you're faced with the question of is this a service contract or is it a sale or lease, the question is does the buyer merely direct and control the operations of the property, or do they actually take possession of it? And in this case, the contracts are clear and they speak for themselves. Karvo at all times owns this property. They own it before the construction contract, they own it during the construction contract, they own it after the construction contract. Their names are stamped on this stuff. This is Karvo's property. And what they've said is, well, look, the state of Ohio tells us where we have to place this and exactly what kind of property we use and exactly what it's going to cost. Sure they do. This is a cost plus contract. This is a normal contract in the construction realm. The construction contracts are service contracts for the construction of property. And under Ohio law, including Ohio administrative rules, materials used and consumed during the construction process are subject to sales tax on the contractor. And you think about, I contract with somebody to build a house for me. Me, as the home buyer, I'm not paying sales tax on the windows, the wood, the shingles. No, those are incorporated into the construction contract. The construction company pays those costs. They may pass those costs on to me in the form of elevated prices, but those costs are paid by the construction contractor. And if my construction contract includes the use of temporary structures, and I say, I need a deer fence to let my lawn grow while you're building a house, what Karvo would have you do is say the home buyers now has to pay tax on that deer fence, even though it's removed at the end of the project and taken away by the construction company. That's not the way construction contracts work in the state of Ohio. That's not the way cost-plus contracts work in the state of Ohio. And so somebody pays the sales tax, right? If Karvo doesn't pay it, the ultimate consumer pays it. That's how sales tax works in the state of Ohio. And what they're asking you to do is bless a sea change on cost-plus contracts where line items in the contract are now subject to be paid by the consumer. In this case, Karvo says, well, hey, it's the state of Ohio, nobody has to pay that. The state of Ohio is not always the consumer in cost-plus construction contracts. So, as I said, this just isn't the way construction contracts work in Ohio, and it would be a sea change. Tellingly, Karvo doesn't cite a single case in support of their position, because there aren't any. The only case relied on by the Board of Tax Appeals is just not applicable. The Board of Tax Appeals cited Dresser, which was a case where the federal government hired a contractor to make some prototypes for them. The way federal contracts work, before, during, and after the construction process, everything the contractor buys is federal government property. And the court said, look, at the end of the day, they got a tangible item, those prototypes. The federal government got that item, they kept it, they took it with them, they took title of it, that's a sale. So the materials that the construction company bought were resold. In this case, the state of Ohio does not take title at any time to the traffic maintenance, barriers, the barrels, the signs. The state of Ohio has nothing to do with that. And I want to talk about one particular piece of traffic maintenance property because Karvo highlights it in its brief. It's probably their strongest piece of equipment that they think should be exempted. And if you look at the contract, there are multiple line items included in what is traffic maintenance property. So there's the concrete barriers, there's signs, barrels, all sorts of stuff. The one thing they pull out as highlighting why this is a lease arrangement is these message boards that are programmable. You see them when you drive through construction area, one lane ahead or something like that. Just as by way of background, even if this court were to decide that particular item was leased, out of one of the construction contracts in the record testimony was taken on pages 61 to 62 of the hearing transcript, out of the $9 million contract bill, those cost $27,000. So we're really talking about a very small part of the assessment. But Karvo highlights it. Why? Because the state can mandate what message is displayed on those boards. But actually, if you look at the contracts, those message boards do nothing but reinforce our position that no transfer of possession occurred. Why? Because the contracts say, with regard to those message boards, the contracts specifically spell out that the state is allowed to have access to them. That's the only piece of property in this assessment where the contract specifically says you have to let us have access to those message boards and you have to let us be trained on how to program them. But the contract goes on to say 24 hours a day, Karvo is charged with placing, maintaining, removing those pieces of property. So, that's a message board that Karvo hauls out, they set it up, and sometimes they program the message from the state, sometimes the state programs the message. Again, that's in the hearing transcript at 61 to 62. But in the ordinary course, what we're talking about is movable concrete barriers. That's the bulk of this assessment. The big wall barriers. Karvo owns those. So they buy them before the contract is ever done. They move them pursuant to the contract. Of course, they place them where the state wants them to place them. If you're building a house, you build it where they told you to build the house. That doesn't mean the state possesses it. That means they're following their contractual obligations as a construction contract. So, to go back to the cases that I discussed before, Laurel Transportation, Flyway, Stein, the clear principle that emerges from those is if the buyer does not take possession, but merely directs the operation use of the property, then it's not a sale and it's not a resale. An analogy there might be the difference between when I arrive at the airport, I can rent a car. I'm in possession of that car when I rent that car. Or I can hail a taxi. I'm not in possession of that taxi. The taxi is being directed and controlled by me, for sure. I'm telling them where to go, where to pick me up, where to drop me off. But the driver is being supplied, the operation of the vehicle is being done by another company. That's a case where that's a taxable service. Let me move on from there and talk about the affiliated groups. As I mentioned before, an affiliated group is a statutorily defined term. And in the sales tax chapter of the Ohio Revised Code, the General Assembly has seen fit to provide one definition of affiliated group that's used throughout any of the sales tax laws that use that term. And what they say about an affiliated group is that it's two or more persons in a situation in which one person owns and controls the other person. And the BTA looked at that and said, well, in this case, it's clear that Mr. Carbonatus was directing the operations of both companies. He seems to be satisfied. What they failed to do is read the next sentence of that statute, which says, in the case of corporations with stock, one corporation owns or controls another if it owns more than 50% of the other corporation's common stock with voting rights. Now, Karvo is an S corp, so we're talking about in the case of corporations. It's an affiliated group if they can control the operations of that other entity. And in this case, they don't have the objective right to control the operations of that entity. Now, what Karvo said is, well, look, the majority owner of K&H signed an affidavit, a handwritten affidavit, that gave her husband full control of the company. That's not good enough. As a matter of law, what we're talking about is voting rights in that company and a majority owner voting rights. He doesn't have that, and he's not Karvo. Again, this is a strict and objective ownership test. This is the kind of test that the General Assembly has said, look, we don't want to get into, does somebody have an affidavit? Is somebody actually controlling this company? This isn't a subjective test. We're asking you, do they own 50% or more of the voting stock? In this case, they don't. But like I said, even if you look past that statute, he's not controlling K&H other than directing the daily activities of K&H, but as an organization, he's not a majority owner. So he doesn't have control any way you slice it. One other point on that, and we cited a couple of cases in our brief, the affiliated entities provision is an exclusion from a taxable service. Exclusions from sales tax are strictly construed against the taxpayer. It's their burden to show that they meet exactly the terms of the statute. We cited HR options and Baker Handbook for that. One more point while I'm on the question of legal standards. Karvo's brief attempts to frame the question of possession of the traffic maintenance property as a factual question and one that this court should defer to the board on. That's not the case. Possession is a term of art. It's a term in the statute, and it's a term that the Supreme Court has wrestled with no less than 5 times. So to say, well, the board found as a matter of fact that there's possession, that's not correct. It's a legal standard, and you apply the facts of the case to determine whether possession existed. This court reviews that determination of the board to no vote.
You just over 2 minutes.
Okay. Well, with that, I'll take a seat and reserve the rest of my time for rebuttal. Thank you.
Thank you.
Good morning, Your Honor, Your Honors. Please the court. I'm Steve Domingo, representing Karvo Paving Company, and I'm respectfully requesting that this court affirm the Board of Tax Appeals on its 2 holdings and reverse the board on its 2nd holding. Affirm the Board of Tax Appeals on its holding that the traffic maintenance property that's been described, fully briefed, was sold via the lease to the state of Ohio, and also affirmed the board with respect to Karvo's lease of employees from its related company, K&H Excavating, because the 2 entities are under common control. Both of those questions where I'm asking the court to affirm respectfully the board's decision involve factual questions. I'm not sure how they evolved into legal questions. They're factual questions as to, in the latter, whether there was control with respect to, common control with respect to the two entities, and possession. There's not a lot of cases on this topic because it's a factual question, possession of the property. And counsel's reference to ownership of the property is totally irrelevant. Hertz owns the rental car, and if Hertz provides a driver for you with that car, just like the Laurel Transportation airplane case, in other cases when they provide an operator, then of course possession isn't transferred. But in this case, with respect to these factual questions, in this traffic maintenance property, possession is transferred. That is the explicit, specific finding of the Board of Tax Appeals to which this court is to give deference, because there is relevant probative evidence to support that. And I'll go in a little bit more detail concerning the transfer of possession. They're trying to dodge the issue, the tax commissioner, by making it all of a sudden a legal question as to whether factually I have possession of this pen. You know, that's a legal question? I mean, there's all kinds of relevant criteria as to whether possession of that property exists. But let's get back to the basic fundamental rule that's relevant to two of these issues. And that is, all Karvo had to do to support an exemption for the traffic maintenance property is to prove that a sale occurred. It purchased the property and it sold it by transferring title or possession. Title or possession in exchange for consideration. The state of Ohio sends out a bid and says, contractors, if you want this work, you have to provide message boards, barrier walls, temporary guardrails, temporary traffic signals, very explicit as to what you have to provide. And the state of Ohio even has some of that property that's on the job. And Karvo bids on it. It's more efficient for Karvo to procure it because they're the ones that are controlling the pace of the job and when it's placed. So Karvo will buy this property and convey possession of it to the state of Ohio, consistent with the explicit request from the state of Ohio. Give us this property. The state of Ohio does have barrier walls in its inventory. It does have traffic maintenance property. It does have these message boards, but not enough to fulfill the requirements that are needed on every single job. And so Karvo bids on it. It receives it tells the state, the Department of Transportation, what that price will be, and it gets paid for the rental of that property. That's explicitly what the Board of Tax Appeals held, that it was getting paid for the rental of this property. And so the tax commission tries to confuse the issue. There's a rule out there that says, an administrative rule that says, all of the tools that a contractor purchases and uses on a job, the contractor has to pay tax on that. The hammer, the saw, the drill, the jackhammer. Of course, the contractor has to pay tax on it because the contractor maintains possession of that property, the hammer, and is using it to perform the job. Of course the contractor pays tax on that. This isn't that type of property. Contractors ask to provide it and then relinquishes possession of the property to the state of Ohio. Why? Because the state of Ohio, Department of Transportation, has an obligation to maintain this traffic safely. 24 hours a day, 7 days a week. Karvo's only on the job less than 50 hours a week. So they tell you exactly what the property has to be, where it's to be placed, the quantity, and you can't, Karvo, once they place it, they can't do anything with it once it's placed. It could be there for 6 months. You can't do anything with it, have no interaction with that property until the engineer tells them to move it, and the engineer even has to sign off on that property when it's even being placed. So it's fully supported that possession's relinquished so that the state of Ohio Department of Transportation can fulfill its public safety obligation 24 hours a day, 7 days a week, and it actually takes the place of property that had been there. As you know, when you see a guardrail might be there that protects the drivers on 77, now they are repaving one lane, so they put a temporary wall there that Karvo rents to the state, taking the place of another wall that had been there. So it's clear possession is being transferred, and that's what the Board of Tax Appeals found. The Department of Transportation has the risk of loss associated with that property. Again, it's even fungible with respect to other property the department has. Sometimes the department even buys the property at the end of the job and says, you know, we actually think that guardrail or that barrier wall, we think we need it there indefinitely. So we're going to buy it from you to continue in the same spot you placed it at our direction through our engineer. We're going to have you continue to, we want that property permanently there. We're going to stop leasing it from you, which is further reflective of, it's for their purpose, not our purpose. The record reflects that, in fact, we had total say. If this was like a tool that we were using in our job, we wouldn't buy this property for the safety of our workers. We don't need it for the safety of our workers. We would structure the jobs in a way that they were always kept safe. We would perhaps only work on small portions of it. We would have, you know, the barrels, and that would be a lot more efficient. We don't do this for the safety of our workers. And the record reflects that, and the Board of Tax Appeals found consistent with that. So to say that this property is like the tools that a contractor normally uses, or is it even like the materials? Really? Materials? These are like the materials in a building, a brick, and so forth that is consumed by the contractor, or deemed consumed under the sales tax laws. But no, these aren't materials. This is stuff that the state of Ohio specifically requests, and then we're required to convey that. So that is the first sale that's at issue. We're asking the court respectfully to simply give deference to the Board of Tax Appeals factual finding that this was, traffic maintenance property was in fact, the possession of it was in fact conveyed. The second sale is Karvo leased tons of used property from its related company, K&H. K&H had actually used this property in its own excavation business for about 7 years. And then it started leasing it as it wound down its operations. K&H started leasing this property to Karvo while it was also leasing its employees. Well, since a lease is a sale, because you're transferring possession, and the tax commissioner doesn't dispute that there's been a transfer of possession of the leased property, why isn't there a casual sale? And the tax commissioner says, because you can't have a casual lease. Well, why not? The statute, this is a legal question, the statute literally says that all you have to do is purchase somebody else's property that's been used. The statute doesn't actually say used, it just says as long as that property's been subject to Ohio's taxing jurisdiction, and the cases have said that means it's something that you didn't buy and hold for sale. As long as it was a property that you purchased for use in your operations, when you turn around and sell that, K&H had actually outright transferred title, there'd be no issue. We wouldn't even have a discussion. The tax commissioner would concede that it's a sale, and therefore the casual sale exemption applies. We're respectfully asking this court to extend that to a lease. That's also a sale. A lease is a sale, it's a legal question. This court can address that topic. The Board of Tax Appeals on the legal front said no. A lease does not qualify. And we think what's particularly influential in this case is the fact that this is a lease where it involved a related party and their operations were kind of winding down. They were just leasing the property to have an income stream to pay off the obligation that the lessor had when they first bought the property. The lessor used it for 7 years and then turned around and could have sold it to Karvo, but in an outright sale of a transfer of title, but it chose to sell it via the lease, and while it was also leasing its employees. And so there's two sales that are relevant: the sale of the traffic maintenance property, and if, to the extent Karvo sells or leases that traffic maintenance property on public jobs, it has to collect tax. The fact that it's not collecting tax from the state of Ohio isn't relevant. It still is a sale. And then with respect to the casual sale exemption, the whole purpose for that is you shouldn't have to pay sales tax on the purchase of property when somebody else had used it. It's already been subject to Ohio's or any state's taxing jurisdiction. And in this case, this was used property multiple times. It was used by the person that sold the property to K&H had used it in an excavation business. K&H came on and bought this property and purchased the property and used it in its own excavation business for 7 years, and then it turned around as it wound down out of that excavation business, turned around and leased it to Karvo, just so it could continue to pay off its obligation to the original purchaser that it bought the property from. The last item I want to address is the fact that the Board of Tax Appeals made factual findings with respect to common control with respect to K&H and Karvo. And it's surprising to hear the tax commissioner in the briefs and even today say that the only way you have common control is this one entity owns the other entity. That's not true. And the explicit provision that he's referring to only applies with respect to two entities that are corporations. If one entity needs to own more than 50% of the other entity, stock, it says voting stock, and we have an LLC here with respect to K&H, so there is no voting stock. But even then, if you have two corporations, the tax commissioner itself even respects that two corporations are related if they have one person that owns or controls both of them. And we have the authority in our briefs that recites that. Two entities, two corporations themselves are related, brother and sister entities, even though one doesn't own more than 50% of the other or control the other. In this case, the Board of Tax Appeals made a factual finding that that Karvo and K&H were both controlled by one person. George Karvinides controlled Karvo through his 100% ownership of the stock. George Karvinides controlled K&H Excavating through a combination of 45% of his ownership of the stock, plus his wife, who owned the other 55%, appointed him in a manner that gave him complete control over the operations. And on that note, even if he wasn't appointed to have complete control by his wife that had 55% ownership, the tax commissioner itself, in private letter rulings, recites situations where a husband and wife are essentially deemed to be one, so that whatever the wife owns, the husband's deemed to be owned for purposes of this test. So, in conclusion, again, we're asking the court to respect the factual findings of the Board of Tax Appeals with respect to this common control question, made a factual determination that there was common control. That's not tied to just ownership. Common control. And the factual question concerning the transfer of possession with respect to the traffic maintenance property. We're asking the court then also to address the pure legal question: can you have a lease that's a lease of used property that had been used, I should say, used by the lessor to Does that qualify for a casual sale exemption? And we say, yes, it does, on a legal basis. Thank you.
All right. A couple of points I want to clarify for the record because I think they were, council misstated or oversold. One thing is, and this was in the brief too, that Karvo is only on site for 24 hours a day, or for 50 hours a week, and therefore somehow the state of Ohio possesses it. You read the contracts, Karvo is responsible for 24-hour day maintenance, and I just pulled one page here. This is in the tax commissioner's statutory transcript, page 81. I don't read from it. The contractor shall be responsible for 24-hour per day operation and maintenance of these signs in the project for the duration of the phases when the plan requires their use. 24 hours a day for the duration of the contract. So this 50 hours a
Did you
week.
say for the signs?
This was for the signs, yeah, but there's other examples for every other part of the property here. That's their job. Karvo is engaged to provide, maintain, and operate all of this traffic maintenance equipment for the duration of the project. So the idea that possession transferred to the state because the state asked for it, well, yeah, they asked for it. That's part of the contract. When I buy a house and I ask the construction contractor to please put in Pella windows, I'm specifying I want Pella windows in my house. And I want a cooler sink. Does that mean now I'm in possession and I owe the sales tax on those because I specified that I want Pella windows and a cooler sink? No, those are items in the construction contract. And if I say to the construction contractor, please place a temporary fence so the deer don't eat my grass, and the construction contractor removes that at the end, that's on the construction contractor. That's not my purchase. Do you have,
No, I'm just wondering why you don't walk away with the windows and the doors. Construction either.
Right. Well, yeah. So, right. Well, that's a leave behind item. But so that's why I say my more apt sort of analogy is probably the deer fence. Keep the that's not a leave behind. The contractor takes that with them and they move that to another job. And they're not charging me as in possession of that. And in fact, in this very contract, it requires Karvo's employees to use night vests. It says every employee must wear a silver and reflective night vest when you work at night. Is the state in possession of those because they required them? And they were on state property and they were specifically required by the state. Again, this is Karvo's business. They build roads. And to build those roads, they have to meet contractual requirements, including how do I maintain the traffic while I'm building this road. That's their property that they possess during the duration of this. And as I said, especially with regard to the message boards, it couldn't be clearer. It says, the state, this is something where the state's saying, you have to allow us access to it. Why would the state ask for access to it if they possessed it? I wanted to mention the question of fact, question of law issue really quickly as well.
But you are out of time.
Oh,
You have
okay.
your minute over.
All right. We appreciate it and submit the case. Thank you very much.
Thank you all for your presentations today. This is what we'll take a minute and provide